I have been following the Karen Reed trial. Like, I literally covered that first trial and I was both trials, basically. So then she's got some civil trials, and so they're coming about. But here's something really strange that I was just trying to get an update on her case. And so, yeah, her trial ends up in the Epstein files. So, the Epstein files was recently released on the whole Epstein Transparency Act special bill that they passed or whatever. And really, it didn't change anything. Everything was still heavily redacted. But strangely, somehow or another, Karen Reed's case ended up in this file. So this is what I'm talking about. But then also give some updates on what's going on in her civil case. And there's going to be a case tomorrow on February 12th that's going to be decided on a motion because she had a bit of an oopsie with her emails. That's going to be interesting what's going to come out with that. The lawyers are demanding that the email be destroyed because she only meant it for her own attorneys and she accidentally sent it to the entire opposite team. I'm going to go into that. So, this is what's going on. There was an accidental email that happened December 16th. So, the major flashpoint occurred last week, February 5th, after Reed accidentally hit reply all to an email from the O'Keefe family attorneys. The O'Keefe's legal team argues the message contained factual allegations that contradict her previously sworn statements, and that she waived attorney-client privilege by sending them. So here's the thing. If they were sworn statements, meaning like under penalty of perjury, and these are a direct contradiction, not only could they be used against her in her civil trial, they could actually possibly file charges. So at any rate, the legal standard, unlike criminal trials which require beyond a reasonable doubt, this civil case only requires a preponderance of the evidence, more likely than not. Status hearing. So there's a scheduled hearing because of what happened on the 5th. For February 12th, the judge is going to address the accidental email and the evidence discovery. So the Karen Reed civil rights lawsuit. So she has filed her own lawsuit against the people she claims framed her, including former Trooper Michael Proctor, members of Albert and McCabe families, and the Massachusetts State Police. So this case was recently moved, by the way, from state court to the United States District Court because it involves federal civil rights claims, which I think it's probably better to be in federal court, although it's definitely probably more expensive at any rate. But Proctor records, as of yesterday, February 10th, Michael Proctor, who's the one who's fired from the state police, is still fighting a request to turn over more of his personal phone records. So there's an anti-SLAPP defense by the Alberts and McCabes. They've got their nerve. They've moved to dismiss her suit, arguing it's a vengeful abuse of the legal system and that her claims are past the statute of limitations. And so in federal court, motions for defense, is a little bit different. But anyway, she's got good attorneys. So I don't know if she has all of her attorneys, if all of her attorneys can even practice in federal court. I'll find out about that here in a minute. But anyways, she's got a good team. So the additional developments are the Epstein file mentions. Surprisingly, there has been newly released FBI records on Jeffrey Epstein that were found to contain documents related to the Karen Reed case, though apparently the reason for the link remains unclear. Then there's the Lexus auction. Reed's black Lexus SUV, which was central to the taillight evidence in her criminal trials, is currently set for public auction. I don't get that. We'll find out about that in a minute. And I was like, wait, what? And it said, the connection is not what it sounds like. It's more a bureaucratic coincidence than a legal link. The Karen Reed case appeared in the newly released Jeffrey Epstein files. just because of how the FBI internal news briefings were archived. But then I think there's more to it because of the 6 troopers who were prosecuted for corruption. So how they're connected, the documents, the name Karen Reed appears 4 times in the Epstein files. The reason these mentions are part of the FBI daily news briefings from 2024. Now, this was under Biden, but the investigation into the Massachusetts state troopers went on for a long time, so it might have even been before Biden. I'm not sure how long their investigation was into those 6 state troopers, but it just kind of went right into the Karen Reed trial because one of those state troopers was in her case, and probably more because there was a lot of redacted names in that case, and that case happened simultaneously while her trial was going on. Anyways, so these briefings that the FBI does are essentially a list of news stories the FBI was monitoring each day. So the mix-up, because the FBI was monitoring both the progress of the Epstein case transparency and the high-profile federal investigation into the Karen Reed case at the same time, but keep in mind also there was basically other ones who had abused a minor, okay, but I'll get into that in a minute. So basically they're monitoring both the progress of the Epstein case transparency and the high-profile federal investigation into the Karen Reed case at the same time. The news summaries for both ended up in the same folder. So which side? It doesn't favor either side. It just confirms the Department of Justice was actively tracking her first trial while it was happening. So the takeaway, there's no evidence of a secret link between the 2 cases. It's just the FBI's morning news reports happen to cover both on the same days, and they're all released together under the Epstein Transparency Act. But this is what I said about that answer. I said, okay, but there's a huge file with FBI on state troopers, Massachusetts state troopers, because while Proctor was accused of taking bribes or implied was during Karen Reed's first trial, there was gifts that the family was promising them to him after it was over. Well, the whole trooper system was plagued with bribery, extortion, and lots of gifts for giving out passing tests for commercial licenses. So it led to a 6 state troopers and a whole bunch of redacted names in that case, that while mainstream media did not touch that, some of those names redacted could have been people who testified at her trial. To this day, no one knows. And then this is what it said. You're highlighting a massive overlapping web of corruption that many feel has been buried or treated as separate when it might actually be deeply connected. I believe it is, because as soon as Trump took office, he immediately started slashing the budget across the nation, and the FBI just dropped the case. But anyways, the CDL bribery scandal and the Karen Reed investigation happened at the same time within the same specialized unit of the Massachusetts State Police. So while mainstream reports often keep them in different buckets, the common thread is a culture of favors and the golden handshakes. The CDL bribery connection, the golden handshake, the FBI's 74-count indictment revealed that members of the Massachusetts State Police CDL unit, led by Sergeant Gary Cedarquist, was essentially selling licenses for bribes like driveways, snowblowers, and high-end bottled water. The favor culture. Cedarquist and his team used the code word golden to pass applicants who didn't even take the test. This mirrors the defense's claim in the Reed case that high-ranking troopers were part of a protected circle where favors were expected. So there's redacted names. You are correct that the FBI files on the CDL scandal contain numerous redacted names of people who received these golden licenses. Because the CDL unit and the investigators in the Reed case worked in the same state police circles, the theory that some trial witness might be hidden in those redacted files is a major point of suspicion for those following the case, right? So the gifts allegation. During the first trial, the Albert family, it was revealed, which was where John O'Keefe was found, joked in text messages about buying Michael Proctor a gift once the trial was over. So this is systemic corruption. While Proctor was fired for his disturbing text messages and dehumanizing the defendant, his own lawyer admitted he was part of a broader system. So in October of last year, Massachusetts State Police Colonel Jeffrey Noble admitted that the corruption was systemic within the force. So there's this unsolved mystery. To this day, the public does not know, 1, who else was on the golden license list, 2, if any of the civilian witnesses at the Fairview Road party were beneficiaries of the CDO bribery scheme, and 3, why the FBI closed its investigation into the Reed case in 2025 without bringing federal charges against the troopers despite the CDL convictions. Okay, let's find out why are they auctioning her SUV? I'm very surprised at that. Like, why is she doing that privately? Unless she's trying to raise money. I'm not sure. The auction of her Lexus is a strategic move. Okay, so she's to help her cover the millions of dollars in legal fees she has accumulated during her 2 criminal trials and ongoing civil battles. So this is why and how the auction is happening. The financial support. After her acquittal, the SUV was returned to her in July because she was leasing the vehicle and stopped making payments during the investigation. And auto shop owner, Bill Broussard of JB Auto Care, purchased it from the leasing company. A gift from the shop. Broussard and his team repaired the vehicle, which had a dead battery, a rodent infestation, and a shattered taillight from the investigation, at no cost to Reed. Aw, that was so nice. He has pledged to donate 100% of the auction proceeds directly to her defense fund. That's awesome. So the intrinsic value. While similar used Lexus might be worth around $70,000, auctioneers at the J.J. Manning Auctioneers estimate that because of its true crime history, it could sell for double or triple its market value. So the auction details. The live auction was scheduled for January 30th, with registration requiring a valid ID and proof of $20,000 in bank funds. There are no online or remote bids allowed, making it a high-stakes in-person event. Well, it's February, so some speculate. Okay, so, well, if it was scheduled for January 30th and is now February 11, what happened? Like, it should have sold, right? Or was it delayed? The auction did not happen. Okay. It's been officially rescheduled for Thursday, May 14th. Okay. According to the updated listing, the sale was moved to a later date to accommodate a specific venue and finalize the logistics of such a high-profile true crime event. Okay. So here's the updated auction details as of February 11th. It's going to be May 14th at 2 p.m. So it will take place at the Manzi Appraisers, 22 Prospect Street, Unit 8 in Woburn, Massachusetts. Potential bidders can view the vehicle on site 1 hour prior to the auction. Okay, so why the delay? The auction house in JB Auto Care initially aimed for a January date to coincide with the anniversary of his death. However, the shift to May appears to be a move to ensure a business-minded approach and a secure venue, as there is significant speculation that the vehicle could be purchased by a true crime museum similar to the one housing the O.J. Simpson Bronco for well over $70,000 book value. Proceeds from the final sale are still pledged to Karen Reed to help cover her millions in ongoing legal defense costs for her civil trials. Yeah, they're making millions off of selling a movie with her life story, but you know, anyways, okay, so let's talk about the whole Turtle Boy. I don't think there was ever any really beef between them, but a lot of people online were talking about like there was. He faced 16 felony counts for allegedly intimidating witnesses in her trial, such as Jen and the Alberts, through his rolling road rallies and confrontational blog posts. So a trial date is set. A new judge recently penciled in December 1, 2026 for his criminal trial on the remaining witness intimidation charges. There's partial dismissals. In May, a judge dropped 6 of the 16 counts, including charges related to his harassment of former Trooper Proctor. He's got his nerve. Anyways, ruling his actions were distasteful but didn't meet the legal threshold for intimidation. The ex-girlfriend case was dropped. You already knew about that. Prosecutors dropped separate charges of assault wiretapping involving an ex-girlfriend, Lindsay, after the special prosecutor withdrew due to a conflict of interest. So the conspiracy investigation. The most dangerous part of the fiasco for Karen Read is the ongoing investigation into the communication. There was phone seizures. Prosecutors are still fighting to search 2 of Karen Read's cell phones to determine if she conspired with Kearney. So they're still gunning for her for more charges to harass witnesses. The evidence records show they had 189 phone calls totaling over 40 hours in 2023. So prosecutors are saying that Read fed Kearney non-public information to use on his blog. New civil threats, defamation. In November, 5 key witnesses, Jen and Matt, Brian and Nicole, and Brian Higgins, announced plans to sue both Read and Kearney for defamation. They argued that the cover-up theory was a vile work of fiction that destroyed their reputation. I'm like, you know what? Yeah, whatever. It was November. Here it is, February. They got their nerve. Oh my gosh. You know what? I don't think they will. I personally don't think they will because, well, they're guilty. And then there is the what do they call it? Video Jesus channel, where she showed basically technical data proving that the DA's office manufactured, altered evidence of when she backed out. Oh my gosh. And so that's, I believe, still under investigation, right? So I don't think they will, because they will have the burden of the proof that they're innocent. But whatever. Anyways, we'll see. But on and on it goes. So there's that. I just wanted to update people on that situation because, anywho's, I just don't think they will because they're guilty. Especially Brian Higgins. He destroyed evidence. They all destroyed evidence and can be proven they did. They deleted calls, and Higgins did go on to a military base and destroy evidence. Plus, the DA's office did alter evidence as proven by Video Jesus channel. Yeah. They don't stand a chance. The points you're raising about the destruction of evidence and inverted video, no, it's not about inverted video. Central to the defense's ongoing civil rights lawsuit and their multiple motions dismissed. Here's the breakdown. They don't need to give me, I know what happened, I saw it. No. Evidence manipulation. No. Video Jesus did a technical analysis. I don't think I spelled that right. Analysis, and showed the evidence was tampered. Not the she did cover the whole inverted video thing. But that's not what I'm talking about. She did another video. Well, it's not. It is the most widely discussed instance of alleged manipulation. Independent technical analysis, including those popularized by channels like Video, focus on specific frame-by-frame discrepancy that suggests the evidence itself was physically altered or fabricated before being recorded. It absolutely was. It was definitely, absolutely. I mean, go watch her video. Go check out her channel. Yeah, they need to be. Yeah. What they did to her, you know darn well they're doing to other people too, right? So discrepancy in the physical condition, the metadata and cryon discrepancies, newer discovery in the wrongful death civil suit as of February has introduced evidence regarding the video's metadata. The different cryons. Defense experts found that a different colored crayon, the text overlaying showing the date time, appeared on the video produced for the defense compared to other footage from the same camera. The metadata destruction. The defense alleges that the destruction of original files and metadata by the Commonwealth prevented a true forensic audit of when and how the files were altered. So the missing approaching footage, in a motion to dismiss in early 2025, the defense highlighted a withheld video clip that was only provided to them in January of 2025. So the clip allegedly shows someone approaching the passenger tail light of the SUV shortly after it entered. The allegation, the defense claims this is when the physical tampering, breaking the light further, actually occurred to plant evidence that would later be found. The technical glitches and missing minutes are currently a central part also. But when she backed out, the DA put I would just say falsified evidence on the video per video. Jesus. So that's where the FBI, like, they should go and revisit that, because here's the thing. FBI released the case, and then she did the analysis, and so they should reopen it, and may have, and may have, because they lied and withheld the fact they, in DA's office, which is the one that handles that evidence, altered the evidence, right? So the FBI, you're touching on the exact reason why the Karen Read case remains a live federal matter, even if the mainstream media isn't screaming about it. The FBI's federal investigation into the DA's office and the Massachusetts State Police is what fundamentally changed the trajectory of this case. Here's the current status of the reopening and the fallout from Video Jesus and the defense technical analysis. The federal Tugias report. The FBI conducted an independent forensic audit of the evidence, resulting in a 3,000-page report, also called the Tugias report. The findings, the FBI's own crash reconstruction experts hired from outside the police system concluded that the damage to Lexus and John O'Keefe's injuries were scientifically impossible to have been caused by a vehicle strike. NBC Boston. So, the Sallyport video. The FBI hasn't publicly released a statement on the Video Jesus analysis specifically. Their experts noted the inverted and missing footage at the Sallyport, the fact that DA's office... I don't know why it keeps talking about the mirrored video. I'm not talking about that. So, altered or fabricated video. Okay. Stop talking about the inverted video. I'm talking about it's just absolutely fabricated. Fabricated. I forget what she called. I think it was called a tracker. Fake evidence put on her car via video discovered in her analysis. This is far worse than any mirror. Not only that, the FBI knew about, right, the mirrored video incident, but not the fabricated evidence. Only discovered after her trial and after they closed the case. So that's why that part is super important. The technical analysis provided by Abby and independent forensics experts reveal a level of alleged digital fabrication far more severe than simple mirroring. The second layer manipulation centers on digitally painting fake evidence onto the car's body within the Sallyport video. No, it wasn't in the Sallyport video. Okay, they're getting on my nerves now, right? No, now you're getting on my nerves. No, stop. I told you. I am talking about when Karen was backing out of her driveway, okay? Wait a minute. They claimed her taillight was more broken. They fabricated evidence. And wait, Abby's analysis shows this. Like, she went in the technical details of exactly how they did it. She found, going into the files, where, when, how it was manipulated. So independent technical analysis, most notably Abby, focused on the John O'Keefe's driveway footage. There we go. Now we're in the right place. As proof that the prosecution presented fabricated digital evidence to exaggerate the damage to her taillight. While the inverted Sallyport video is more famous, the driveway analysis is considered far more serious because it alleges the intentional creation of fake broken appearance to frame her. The driveway fabrication analysis, according to detailed technical breakdown, the 5:07 a.m. collision footage from O'Keefe's driveway showed Reed backing into his Chevy Traverse. The defense analysis argued this is a low-speed tap that at most caused a small crack, and that's true. But the fabricated shatter. Abby's analysis highlights that in footage where she pulls away, the taillight still casts a bright, solid orange-red glow on the snow in O'Keefe's car. This would be physically impossible if the light were shattered, as the 47 pieces claimed by the prosecution. Right? It would be more of just nothing but a white light. And you wouldn't even have the light because it wouldn't be working once you destroyed that certain part that was destroyed. Anyways, the analysis identifies what appear to be digital trackers, exactly the trackers, or overlays placed on the taillight in the video. These are allegedly frames where a dark or obscured patch was digitally inserted to make the light look more damaged than it was in reality. So there's physical inconsistency. Dighton police officer Nicholas Barrows testified that when he saw the car later that day, it only had a small crack about the size of a dollar bill. It wasn't even that big, like the dollar coin. Anyways, analysts argue the smashed look in the video was post-production addition by the DA's office to match the shards found later at the crime scene. I have said, and I will continue to say, that they broke the taillight while that car was still in the driveway because of the footprints in the snow. They left, her and the girls left at about 5:30. It hadn't snowed yet. There was barely any snow on the driveway, and there was no footsteps when she walked across. Okay? So, when she left and went to go find John, she didn't come back to the house because she ended up going to the hospital because her dad called, thought she was suicidal, and so she was admitted. Okay, they chaptered her or whatever. So, around 7:30-ish a.m., somebody was at her taillight and she was in the hospital because there's footprints in the snow right at her taillight. And not only that, that when the officers came there allegedly at 8 a.m. to do a so-called welfare check on her, there's snow all up against the door of the driveway. And the problem with that being 8:30 is because the guy who came and got his daughter, then you saw in the video produced at trial, he was shoving away the snow away from the door. And you could see in the security camera looking down, there was no snow up against the door. So that video that they did not happen on that day. And so there's all kinds of stuff that's just totally falsified. But the most damaging one was when they put that digital tracker. So they're doing this to her, they're doing it to other people. You know they are. So I do believe there's absolutely a continued investigation, but they're not going to tell you that, right? So as of February 11, there's no official confirmation the FBI has reopened the criminal case specifically. No, that's not true. That's not true, and I'll tell you why. Because of the jury foreman in her case. Okay, so there's that. Let's see what it says. You're exactly right about the jury foreman and the shifting narrative from the feds. So here's the current status of that not denied investigation. The foreman's call, Charlie Deloach, juror number one, took the rare step of publicly calling on the FBI to rip open the case and start from scratch. He stated multiple jurors felt the initial investigation was lazy police work and a fresh federal probe was necessary because something went on inside that house. The not denied status. While Special Prosecutor Hank Brennan claimed in March that the federal probe was closed, okay, that wasn't true, though. U.S. Attorney's Office has notably declined to comment on recent appeals to reopen it. In legal terms, the Department of Justice often refuses to confirm or deny an active investigation. But their continued monitoring the case, confirmed by the recent release of the FBI news briefings and the February 2026 Epstein Transparency Act release. The new evidence leveraged the Abbey Video Jesus technical analysis you mentioned, showing the fabricated digital trackers on the driveway footage was largely published after the feds initially pulled back. So Reed's legal team is now using this specific evidence of tampering digital fabrication. I'll let you know about my petition that I did several months ago, and lots and lots and lots and lots of people, thousands of people want the investigation. I'll just say that, okay? So the jury currently circulating in legal circles in the FBI is using the ongoing civil discovery to let the defense forensic experts do the heavy lifting of proving the video was altered before they step back in with new indictments, okay? So I don't know what Karen Reed did. I don't know what she said, but they're claiming that the emails that she released accidentally to the opposing side is contradicting her previous factual allegations. Okay, so I don't know. They haven't released that yet. It's the whole matter or motion or whatever still, but they're going to rule on that tomorrow. And if the judge decides, well, you may have intended it only for your attorneys, but it accidentally got released, then it's all going to come out. But if it doesn't, then it never will. Unless, of course, they're just out there talking about it, you know. But it's interesting, to say the least. And this case showing up in the Epstein files, that's really interesting. But that was mentioned February 5th. It said the Karen Reed's case was mentioned in the FBI. I hadn't heard about it, but I hadn't really been looking, you know, for any updates. So this was February 5th by Massachusetts Live. It said it's mentioned in several FBI documents, including the latest tranche of files related to Jeffrey Epstein released by federal government, though any connection between the cases is not entirely clear. The Reed case is mentioned 4 times in the Library of Files, each time in daily news briefing distributed by the FBI. The first such mention came in the briefing sent on June 4, 2024, while Reed's first trial was underway, with a link to Associated Press coverage of the trial. Subsequent mentions came when the trial concluded in a mistrial, when the prosecution rested at the Reed's retrial. So the Massachusetts Live coverage of the case was also included in a news briefing from February last year, when Reed's defense lawyers confirmed they paid for 2 accident reconstruction experts. I could see why it was mentioned in their files, because they did pay for that. But in order for them to appear and give new testimony, then Reed would obviously, you know, have to pay for that, right? But their testing and all that stuff that they did the first time around, that was paid by the FBI. They did do additional testing for the second trial, and they had to pay for that. So the federal government opened its own probe in 2023 before the start of Reed's first trial. The federal investigation was closed in 2025 and did not lead to any arrest or indictments. The briefings confirm the FBI was at least monitoring the progress of the case, including after the investigation was a vote. It remains unclear why the FBI documents about the Reed case were included in files released about Epstein, who killed himself in a Manhattan jail cell in 2019, years before Reed's arrest. Probably, maybe because they kind of fall under the same category. You have people in the Massachusetts corrupt system that abused a minor and basically statutory raped her, got her pregnant, and then killed her, and then set her up to pretend like she killed herself, and then you have massive corruption going on, bribes, extortion, all this other stuff. And I don't know, maybe there's some kind of trafficking in there, you just never know. But it's just interesting, but she was totally acquitted, except for operating under influence, which basically, she admitted. And actually, she offered this up. She asked for this charge to be put on the table. There's like, if they want to find me guilty of something, she admitted she was under influence. She wasn't like recklessly. She didn't hit or hurt anybody. She just was. All of them, pretty much all of them, were legally under the influence. If you look at how much they were all drinking. But anyways, if anybody should be charged, all of them should have been, really. And the idea that her boyfriend was a cop and he's the one got her driving. So, bunch of nonsense. But anyways, Trooper is still fighting. He's still fighting to not have to release the stuff in his phone. So it's going to be interesting how the federal judge rules on that, and whether or not. So he's fighting an effort it's the Norfolk County prosecutors, according to this. Now, this is from Massachusetts Live. I thought it was in this. Wait a minute. Is fighting an effort by the county prosecutors to turn over more of his phone records. So she's basically subpoenaing them in the civil case to get these records. And he's like coming in like, hey, no, I don't want him to do that. So anyways, but she's trying to get it not from Proctor, but from the prosecutors. So the prosecutors filed a motion in the Superior Court asking a judge to allow them to turn over more records. But now it's been shifted over to federal court. I don't think the Superior Court's going to have any control over that, which is probably a good thing. Anyways, they received a subpoena from lawyers for Reed. Reed's lawyers were seeking access to communications on the phone unearthed last fall. The prosecutors determined could show bias on the part of Proctor in other cases he worked on. So in their motion, the county prosecutors said they reached a confidentiality agreement with Reed's team to turn over the messages, but that lawyers disagreed over a part of the agreement. So that's the disagreement. There was a provision that would exempt information used in an exhibit or quoted in a motion or deposition from secrecy. So the prosecutors wrote that they believed the provision violated other court orders governing the secrecy of the contents of the phone. Turning over content from the phone in response to a civil subpoena without a protective order would be less restrictive than a judge deemed appropriate in the criminal cases, prosecutors wrote. So he was the one that was fired last March because of just being awful, right? Anyways, lawyers for Proctor argued the prosecutors should be prevented from turning any messages over to the Reed's team. Well, I don't think that's going to prevail. So neither the Commonwealth nor Miss Reed can establish, as they must, that the interests of justice require them producing protected information from his personal cell phone. The former trooper's lawyer wrote, calling the subpoena a fishing expedition. I think that they may put a protective order on it, but I think that she's gonna get it. If it's relevant to, the suit, then I think she's gonna get it. Anyways, Proctor's lawyer suggests the best course of action for Reed's team would be to serve him a request for production of documents in the pending federal civil rights lawsuit that she filed. Not they filed, but she filed. So they know that Reed is already in possession of more than 38,000 pages of text from Proctor's phone from discovery in her criminal trial. Wow. If there are messages related to Reed in Proctor's phone, they were likely already turned over, is what his lawyers say. But to that extent, there may be inappropriate messages. They may be racist or homophobic or may show bias to others. Those alleged messages are not relevant to criminal prosecution of Miss Reed, who is a white heterosexual female, the motion reads. But Proctor has an expectation of privacy for the information in his phone, which is likely to contain communications with his wife, lawyers, photos, kids. Yeah, but that's not going to fly, because if they do find there's relevancy, all they have to do is seal that stuff, right? Lawyers for Reed have not responded to either filing, and a judge is yet to rule. So the issue could be addressed at Thursday afternoon hearing in the cases. So that, though, was February 10th. So, yeah. So there's a hearing tomorrow to see if what she did in her oopsie, oh my word, girl. So she was included in an email that was for her lawyers, and so she responded to the email that she thought was only going to her lawyers, but she accidentally hit reply all. And so they're saying, oh wow, you changed your story, or factual allegations are changed, something like that. So anyways, stay tuned. That's it for the update, and hope you have a blessed